The Supreme Court has ruled today on the Voting Rights Act. Section 4 has been struck down by the Supreme Court. Section 5 has not been struck down. What does this mean? I'll explain it. Both of these sections of the Voting Rights Act refer to the provision that designates that there must be pre-clearance from certain parts of the country when they are going to change their voting laws. Now, Part 5 is the part that indicates that the pre-clearance is designated, and Part 4 is the part that designates what is the formula through which the parts of the country that must pre-clear changes is determined, and it specifically outlines, based on that, there were parts of the country which, up until now, had to pre-clear changes in their voting laws. The Supreme Court has not struck down Section 5, meaning that pre-clearance of changes to the Voting Rights Act, or rather to voting laws, is okay. It is constitutional. However, they have ruled that the formula, which has been in place since the inception of the Voting Rights Act, Part 4, Section 4, is struck down, meaning that the states that up until now, based on that formula, had to pre-clear changes to voting laws no longer have to do so. Now, the court's opinion was based on the idea that things have changed since the Voting Rights Act was put in place, that the Congress may draft a new formula based on current conditions for which parts of the country must pre-clear changes to their voting laws, but that as such, the country has changed and that racial discrimination in voting no longer lends itself to requiring pre-clearance in certain parts of the country. Now, what's happening as a result? For example, Texas Attorney General has already said, hey, this means we should pass that voter ID law we've been talking about. We should pass it right away. That is one of many voter ID laws that we talked about so extensively, Lewis, in the lead up to the 2010 election and the 2012 election, which is certainly geared towards disenfranchising or preventing the voting of primarily individuals who would be reasonably expected to vote for more progressive candidates. This is, again, more evidence that, number one, it appears the Supreme Court has not really been paying attention to the shenanigans that go on in many states concerning people's rights to voting, in my opinion. And number two, again, Republicans don't want you to vote. Republicans do better, conservative candidates do better when less people vote, particularly if those are individuals that we can reasonably assume will vote more likely for progressive candidates than for conservative candidates. People need to get out. We need to get active. We need to vote, number one. And we also need to push Congress to create a new formula, because the idea that, hey, racial discrimination's gone, so we don't really need to worry about people not being able to vote, bogus, ridiculous.
Do you think they just assume, since they already shut down what happened in Arizona, that that's not really an issue?
No, I don't think that. I mean, Natan, what is your honest thought about what the court honestly thinks about this?
What the 5 justices that ruled against it think?
Yeah.
Well, I know for a fact that Clarence Thomas thinks that requiring a state or a jurisdiction to pre-clear is itself unconstitutional, because he filed a concurring opinion saying that.
Right.
As for the other thing, it is a valid point that the coverage formula isn't correct in the sense that there are places in Pennsylvania, Ohio, South Dakota, a lot of places that should also be covered, and there are places that are covered in the Deep South that don't need to be covered because they haven't had any violations.
Sure.
But I think it's a wrong decision for another reason, which is that, really this is something that should be up to Congress. Congress is the one that's authorized via the 14th and 15th Amendments to actually enforce this, and they reauthorized it overwhelmingly in 2006. So
98
you can
0.
say, you can say that, like Justice Scalia said, that that vote is meaningless, that this is just going to be reauthorized endlessly. That's a valid point. The reality is that if they could, in 2 weeks, come up with a better formula and before the 2014 midterms have a new formula that makes more sense, that'd be great. It just seems right now like that's unlikely.
Absolutely. We're going to keep following this. We're going to see. We're just going to keep following it. This is very, very concerning. And as we see Texas wasting no time in wanting to move on this in order to pass those voter ID laws, which, as we know, are based on rampant fraud that doesn't exist.